This month, we feature in Flu an unpublished but citable case. I don't want to get too excited about it, except that what's odd is it's the first one in many, many months. We had a couple of published cases last fall, and the Court of Appeals hasn't been doing too many family law cases, for one thing, and when they have, they seem to be all per curiam cases. So I'm going to take the opportunity when there's one that's citable to talk about it a little bit, not only because of the fact that it's one of the few citable cases from the Court of Appeals in quite some time, but also because it illustrates something that I think is a trend in the family law field, and certainly something that has some recent law that's important to it. The case that is in Flu, I'm not going to try to pronounce it. It's I said I'm not going to try, and then I go trying. It's a Greek name, okay, versus another Greek name, and I don't want to try so I don't insult anyone here, but the name of the case is in Flu and will be reflected on this video. And what the case stands for is the issue of a parent coordinator and the powers of a parent coordinator. And what's interesting about the case is it's the first case in the family law field that applies the holding of universal products. The universal processing, is the case from the Wisconsin Supreme Court a little over a year ago that dealt with a major league civil case where the two sides were discovering the you-know-what out of each other, spending all sorts of time, money with huge discovery requests, and Judge D'Amato was, my opinion, one of the best judges I've ever appeared in front of, recently retired. He had enough, and he appointed Judge Michael Skorowski, retired Milwaukee Circuit Court judge, as the referee. In universal processing, they reversed Judge D'Amato's order, saying that it was inappropriate because it conferred the power of the court on somebody who had never been elected as a judge. When I spoke about this to the State Family Court Judge Association earlier this year, I said that I don't think the case barred you judges from making the appointment of a referee under certain circumstances. What you cannot do is vest those referees with the power of a judge. What's the power of a judge? It's to make the binding decisions subject to review only by the Court of Appeals. And that's what Judge D'Amato did in universal processing. He said that essentially Judge Skorowski was going to serve as the finder of fact and make recommendations or orders, but subject to review by Judge D'Amato on an appellate basis of abuse of discretion, as opposed to, and the best example, of course, in family law field is family court commissioners who make orders all the time, but it's a de novo hearing before the circuit court. At least in theory, it's a de novo hearing. And that difference between theory and reality is something I want to point out in terms of the case that came down this week, the one whose name I'm not going to try to pronounce, because the case involved the use of a parent coordinator, and the parties had actually stipulated to it. So it's a little different than universal processing in the sense that in universal processing, Judge D'Amato appointed the referee, the parties can stipulate it to it. In this case, the parties stipulated, but they put a sunset of 12 months on it and said that either party essentially after that point can withdraw their agreement. And the case came back for further review, and the husband, or now ex-husband, said, hey, I don't want to use the parenting coordinator anymore. The judge said, well, you agreed to this, and so I'm going to continue the appointment, and that's reversed by the Court of Appeals. Court of Appeals relied on universal processing to say that courts cannot delegate their power to a third party, that the best that they can do would be to allow a third party to make recommendations to the court, but that recommendation has to be subject to a de novo review by the court. The way this plays out in a lot of family law cases is in a slightly different manner. It's where the parties are continuing fighting and litigating and arguing about custody and placement issues. And whatever it is, there's going to be an argument and a fight about it. And getting into court can be an arduous process. The court has no desire to see these cases constantly. I always tell clients that judges are paid salary, not piecework. You know, make more if you hear people come in 20 times. Plus, just getting into court can be difficult. If you get a first hearing now in Milwaukee County for the Family Court Commissioner, it can take as long as 4 months. I'm not making that number up. It's a long wait. And in other counties, you know, it's 2 weeks if you're lucky on a good day. And if you need an emergency decision that's going to be made, you're not going to get that in front of a judge in time to make it. In those cases, it may be appropriate for the court to make an appointment of either a parenting coordinator, sometimes the guardian ad litem, in terms of making a recommendation in which the court, or the parties rather, will follow, as long as it's subject to court review. And I think the term subject to court review is the key here. I think the court can make that order in terms of emergency recommendations. I'm not even sure they should be orders by the parties. And it would make sense for the parties to follow that recommendation, because you know in 99.9% of the cases that that's what the judge is going to order anyway. Are there cases where judges don't follow the recommendation of a guardian ad litem? It happens, but it's man bites dog stories. In the real world, that's what happens. So it makes sense for parties to agree to that. Clearly, based upon this case this week and certainly universal processing, if the parties don't agree, the judge is going to have some problems making an order that's consistent with universal processing. But even so, it makes sense for the parties to agree to it. For one thing, both of them are going to want resolution, and they're going to want to know if we're dealing, you know, with a Christmas issue and it's December 23rd. Trust me, you're not getting into the court on the 24th to decide it, and the child has to be somewhere. And the worst case scenario is treating a child as a turkey wishbone where each side grabs an arm and starts to pull. Almost any result in terms of which parent the child with is better than that. So I think there is some room around universal processing and taking into account this new case in order to fashion a type of emergency ruling subject to de novo review of the court as soon as the parties can get in there. And I think that would work on a lot of parties. I think it would behoove the parties a lot to agree and stipulate to that. It allows them to get immediate resolution. I know judges, most of them would like that, if they can have someone else make the emergency decision and know that there will be some determination. And it's certainly good for kids in most cases that the fighting will be limited and that somebody's going to make a decision. So take a look at this case. Universal processing, of course, is the underlying case. If you haven't read that yet, it's an important case to look at, and dealing with some significant issues, both legal and societal, in terms of the roles of judges in making decisions, as opposed to delegating those decisions to somebody who has not been elected through our judicial process.